Hi, welcome to another episode of Kidon, War Stories on the Cutting Edge of IP Monetization. My name is David L. Cohen. I'm the owner of Kidon IP, a consultancy, and David L. Cohen PC, a law firm, where we provide IP monetization services to clients both large and small. Every episode, I interview subject matter experts and leaders in the wide world of prosecuting, asserting, analyzing, monetizing, and defending intellectual property rights. You can find the show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and more. Today, my guest is Doug Clark, Principal and Global Head of Dispute Resolution at Rouse, the law firm Rouse. Doug has practiced in Asia for close to 30 years. I'm sure he'll correct me if I get anything wrong. And one might say that he is the founding father, or at least one of the co-founding fathers of contentious IP disputes in East Asia. He's a solicitor advocate of the High Court of Hong Kong. He's also a solicitor's advocate. Doug is a keen IP strategist and negotiator. I know this from experience, having witnessed it myself on both sides. He also is a master linguist of East Asian languages, a prolific author, including I believe, the first treatise on IP law of Hong Kong, and to my knowledge, the only treatise in English on Chinese patent law. Don't get me started about his extracurriculars, which include movie producing, legal history publisher, and a law professor. Most importantly, he's a great guy with keen insights and fun to hang out with. And so, let's begin. With that storied career, I hope your head still fits in the box we have you for the video. But maybe tell our listeners how you got where you are briefly as an IP litigator in Hong Kong, China.
Yeah. So long story short is. Way back in the early 80s, I studied in Japan when I was at high school, went to high school on exchange, which was a great time. I was back at university, but even then, a lot of Australians, you didn't mention I'm from Australia, a lot of Australians had already learned Japanese. I thought it was going to be a great way into law firms having Japanese as a language, but it wasn't. Right. And I saw some scholarships for going to China being advertised. So I thought, well, why don't I go to China, learn some Chinese? Then I should be easier to get a job. So 88, I headed off to China, went to university in Shanghai, Fudan University, studied Chinese for the first year. Then I studied law in the law faculty for the second year, which is an interesting year because it was after June 18, 1989. Made it easier for me to study because the teachers taught to the curriculum, shall I say. Didn't really vary too much. And then I went back to Australia, finished law school. And then 92, I'd always planned to move back to Asia, but maybe not immediately. But 92 was the bottom of a deep recession, same in the US, if I remember. Yeah. Not too many jobs going around. So I decided to head up to Hong Kong in early 93. And I started working on the 1st of March, 1993 in Hong Kong with what was then a law firm called Lovell White Durrant, now Hogan Lovells. Stayed there for 18 years in Hong Kong for a while, and then headed over to Shanghai in 2000.
I'm gonna be careful with my mouse. I think it turns off my camera, but I think we got everything. That's really cool. So I believe we first encountered each other somewhat by a distance. I think you were. I was on the U.S. side, and you were on the East Asian side of the Qualcomm Nokia disputes.
Yeah,
back in the day. So you have a view of the long arc of IP monetization in East Asia, but mostly China. And I guess maybe you could paint a picture of what's changed and what stayed the same, for better or worse.
Well, of course, probably two big things have changed the most, and these are not great insights. But obviously, the money at stake is now much more than it was,
right?
Because you particularly out of China, you're seeing very large companies producing very large quantities of products, and the royalties coming out of China are big. And of course, they were big a long time ago, but they've got extra big. But probably now you're also seeing from the Chinese counterparties real sophistication. They are instructing big international law firms, fighting things, doing in the UK courts, if you read the decisions out of there, they've got more sophisticated arguments, and they've realised spending some money on fighting is going to save them money in the long run, and real arguments rather than some of the previous more like let's just stonewall as long as we can that you used to get. It's trying to build some jurisprudence internationally in their favor that, obviously as implementers they have to pay less. Huawei is a little bit more interesting. We can talk about them a little bit later because they're shifting from being an implementer to a licensor, which feeds into some interesting things in China and what's happening in the law, because you're not getting the extremes that you might have thought of everything being in favor of implementers. And I think that long-term arc is obviously going to be there for not just Huawei, but other Chinese companies too.
Well, what do you think are some of the big stereotypes that the unsophisticated players who want to jump into the IP space in East Asia, and then maybe the sophisticated, some myths that the sophisticated players might be deluding themselves with about IP monetization in China?
Okay, well, I mean, the first, I think there's two things. First is, litigation in China is still a tough game. Damages have gone up, but proving infringement, proving scale of damages is very hard still.
And why is that, Doug?
That's just the Chinese legal system. It has very tough burden of proof. Now, damages have gone up, and there's been some decisions very recently where the courts have appreciated. And this is not just about foreigners coming in; it's even for Chinese companies. There's no proper deterrent. People are effectively being able to be efficient infringers across the board in China, and that has finally come to the courts. And so they've introduced now punitive damages. They've been much more liberal in the assessment of damages, but it's still. If you're looking at it in our space in particular, I think where your space in particular, mobile phones and those, well, not just mobile phone, but the whole mobile equipment sector, still nowhere near where the sort of money that you're talking about are coming out in royalties. But that's a systemic issue of the Chinese legal system because it's always had a strong burden of proof on whoever is asserting something. Where you see, interestingly enough, and where there has been some big awards, I can't talk about in too much detail, but is in the arbitration world, where if parties have agreed arbitration anywhere, very often in Hong Kong, but maybe Singapore, maybe even USA, arbitral tribunals are not bound by those Chinese rules of evidence, and you've seen far bigger awards coming out of tribunals for many years, and there are a lot of arbitrations going on. Of course, the problem with arbitration is it's confidential, and so we only hear little anecdotal tidbits here and there of what's been awarded. But there are, I can say in cases I've been involved in, the claims have been much, much bigger, and the awards have been much, much bigger than you see out of the Chinese courts. It's
interesting because, with just skipping around to arbitration, my experience of the two most important aspects of arbitration is picking your arbiters and figuring out whether it'll be enforced.
Yeah. So enforcement is, in China is much better than it used to be now. If a court doesn't want to enforce, they have to report to the Supreme Court. So enforcement levels have gone up. It takes time, but that's true in many places. Not everywhere. I just enforced an award in Hong Kong. It only took 2 weeks. It was amazing. But sorry.
I'm sure it's all you, Doug.
To get to the order, we haven't actually got the cash, but now we've got a judgment we can enforce. So it's not that quick in mainland China, the other tricks, though, are not just about enforcing in China itself. If you're dealing, depending on who you're dealing with, but if you're dealing with exporters, you've got to put some investment in trying to identify who their customers are, if they have assets overseas, and go after those as well. And try and garnish your customers. That could be one of the most effective things you can do, because customers, hey, you don't pay your bills. What's going on? Get this fixed up before we do business with you. So there can be tricks to the trade on doing that. But you can also go and enforce directly in China. And not to forget, particularly if you have an arbitral award compared to a judgment, you've got 151 countries, I think, in the New York Convention you can go around and enforce in. Right. Probably half of them relatively easy. So that's an advantage. Of course, the problem is you have to have an arbitration agreement. Right. And going back to war stories, you and I are trying to negotiate those ex post facto, and I've never succeeded. I don't know if anyone's actually succeeded after a dispute's arisen, because, as we know, either side at some point thinks litigation is better than arbitration, and having that confluence where they both think it's a better idea is not going to happen.
Yeah, if one side thinks it's better, the other side thinks there's something happening. Yeah. But but on the question of arbiters, are Chinese nationals or Chinese whatever, I guess Chinese nationals, are they participating as arbiters? Is that a thing now?
Yeah, you have some arbitrators now. Of course, you've got to look at your jurisdiction. So and the rules. So, for example, if you're an ICC arbitration, usually they don't appoint nationals, unless the parties agree. I mean, it will be part of the rules. But yes, there are Chinese nationals. I mean, usually if you're having a big dispute, you'll have a 3-member panel. So you'll have probably one appointed by the Western party, one by the Chinese party, who will probably be a Chinese national, and then one appointed by those 2 other arbitrators, or if it's the ICC, the president of the court. So they are. But if you're in Hong Kong, you'll often have Hong Kong lawyers or some other lawyers, common law lawyers, as the arbitrators.
Right.
Just on a war story there, because this is what this topic is, I think. You have some tricky decisions about whether to go to 3-person panel or a 1-person panel. One-person panel is much quicker. There's no doubt about that, because you don't have scheduling conflicts. But sometimes quick is not good, particularly if they're against you for whatever reason.
Yeah. So how do you think, sort of taking a step back about, I guess I'm going to ask the same set of questions, both in the context of litigation, but also in the context of licensees or licensing. In the context of litigation, can you give some particulars about how litigation has changed from the perspective of when you're suing Chinese defendants and you're not?
So it's changed when you're suing a Chinese defendant?
Yeah.
Yeah, well, I mean, let's just put it this way. The Chinese legal system in the last 8 years, I guess, for IP has improved just incredibly. It's so 2014, they set up some IP courts in Shanghai, Beijing, and Guangzhou.
Yeah.
And now they've got one in Hainan Island, which is a little bit like opening one in Hawaii. Literally, maybe it's where you go in winter. I don't know, because it's not a thriving. But that's part of a long-term plan to develop Hainan Island. But that drove other cities to set up IP tribunals. So there's now, I think, 27 IP tribunals set up in courts around China, and that was first a fantastic change to get specialist IP courts. So you have specialist judges. You're probably only seeing in UK, Germany, and Japan the same level of specialism going to a court as you have in China now for an IP court. The judges know their law, know what they're doing, and that's good. There's still some problems in China around political pressures and possibly corruption, although that's been improved a lot.
Right.
But with specialist judges, they have their own professional pride that helps them to avoid that. But the big game changer is actually in 2019 when they set up the Supreme Court IP Tribunal, which hears directly second instance appeals on all patent and high-tech cases. And that's why it's a game changer. First is you get consistency. Every decision from around the country goes there. But it also reduces the potential for political interference massively, because you have to have the reach all the way up into Beijing. And even a first instance court, even if they're getting pressure locally, they're like, look, this is going to go on appeal to Beijing. We can't do anything too extreme. And anyhow, they can admit new evidence. So they can retry it completely. So that's been a big game changer. And that's why we were talking about damages going up. They've been pushing up damages, pushing up even reversal of burden of proof and those things. So the IP world in China is totally different from when I first started litigating in 1999 in China. And that was interesting. We can talk about some of that later in terms of war stories. And all through the 2000s is a bit tough. You mentioned Qualcomm and Nokia. That was the biggest sort of thing to happen. I think we started that in 2007. And that was okay. System was working. Between 2 big foreign companies, we felt some confidence. But it's a real game. The game has really changed. We feel much more confident.
Right. I don't know. My camera is acting funny. I don't know what's going on here. Sorry about that. No, it is a big game changer. I remember when we first started, it was mostly, I used to joke it was good for Westerners to sue Westerners in China, but Qualcomm and Nokia suing each other. But now it seems that you can actually, there's actually a pretty robust system, and
Yes.
it's good to hear that the political interference has been minimized. What about as licensees when you're dealing with Chinese licensees? So putting on your negotiating hat, how has that changed? In that, regardless of where you're actually suing them.
Yeah. Okay. So trying to get to a settlement.
Yeah.
So you're talking not so much like a putative licensee, if we're talking Fran world, I guess.
Fran world, or even if you're suing them in another country, but.
Okay, you'd be trying to get someone to take a license for some reason. Yeah, I've had some pretty good success recently. I mean, it's a hard game, more sophisticated. You get some proper arguments. It still varies massively from some extremely sophisticated companies. I've always said this, like I've had a number of dealings with Huawei over the year, and they are one of the most sophisticated professional companies you'll ever deal with. They may have their problems with the US government, but they are a top quality company to deal with and negotiate with. And from that level, and better than many Western companies, just to be frank, from that level down to still like well, maybe not to the level of we don't think we even need a license, but drag things out, push things along, and not get anywhere. But you get that in every country of the world. But I think it's probably a little bit more in China. Same thing. What pressure are you really going to put on me? Probably the biggest weakness still remaining in China is foreign judgments are, and I have to say for the most part now, not enforceable. I used to say absolutely not enforceable, but there's so few foreign judgments being enforced. Litigation outside China against someone who doesn't have a real presence outside China doesn't really get that much of a pressure point, because they're going to avoid the damage enforcement. And if China is negotiating on the new Hague Convention on foreign judgment enforcement, but even there, I'm not sure they're negotiating on behalf of the mainland, because Macau and Hong Kong are also part of this. And for Hong Kong, they'll sign up straight away. Macau will probably sign up straight away. Although, big news, the Hong Kong mainland China enforcement of judgment rules are going to come into force soon. So that's going to change the game.
Interesting. Yeah.
Except for patent damages, interestingly, the Chinese took it out, not the Westerners. The Chinese said, "Oh no, you won't be able to enforce patent damages awards in China from Hong Kong." Part of the problem there is actually our business, or your business in particular, but our business, because so many mobile equipment manufacturers ship via Hong Kong. Genuine fear that you'd sue them in Hong Kong, say, "Look, multiple millions of handsets or equipment all come through Hong Kong. We get our damages. Now we come into China and enforce it." But it's interesting. It's the only major exception in this enforcement agreement is that patent damages can't be enforced.
Well, that's interesting, because you sort of presaged or sort of foreshadowed my next question. Certain things have stronger political headwinds. Okay, I guess is a good way to put it delicately, like perhaps telecom and perhaps FRAND-related stuff that will often get the government to be involved, or the various antitrust authorities. I think there's only one now involved in your life, as I know a little too well. So is that still going on? And if so, like is it?
Yeah, I mean, at the very top level, and you're right. I mean, SCPs is probably still getting some attention. Well, it's still getting some attention. We've had some, amazing cases. We had the anti-suit injunctions, which seemed to have calmed down a bit. And the first anti-suit injunction was crazy. It was like restraining absolutely everything. You couldn't even justify it on the basis of other countries grant them, because it was just so broad. But they have narrowed them, and the courts, and they haven't issued any, I hear, recently. So I guess even the Chinese courts say, okay, we've set off a few bombs. Now it's time to step back. Not to forget the other courts, like I think Germany now gives you your anti-suit injunction as you file if you ask for it. So that makes a difference. And I developed some theories around claiming damages in the countries where you're going to sue if there's an anti-suit injunction. So So you say, well, if you stop us suing here, then okay, we can't sue you for that, but we can sue you for damages. And you pick local entities to be parties to that. And so the counter measures are slowly being worked through, but there's no doubt there's a large implementer community in China that has been pushing for China trying to set the global FRAND rates, and in many ways they're right. Why shouldn't they? They're the biggest place to produce them. UK sort of said we can, so China's, well, why can't we?
No, of course. I mean, that's sort of the thing, right? China's still I think the workshop of the world is the phrase, sort of power from the Brits back in 200 years ago. But one of the big things, another thing that you foreshadowed, one of the things I see changing, and is the system is becoming, for lack of a better word, fairer to patent owners. And I would argue in large measure because of the success of Huawei, and maybe a lesser extent, Oppo, and I think it was Oppo or Vivo who developed all these patents or acquired all these patents. And now
Oppo, I think, but they're probably the same.
Yeah.
Well, this is something that I talked about even years ago, like back in the everyone talked about, Chinese IP system would improve as Chinese companies became IP holders. And then the pressure comes internally for enforcement. But I think there was some light bulb went off in people's heads because, I started practicing. So I started suing in 1999. Everything got better to about 2007. So we felt the legal system was getting fairer and better, even for foreign parties. Then come 2008, the financial crisis. Well, things got pretty tough for foreign parties suing in China, and probably Chinese too, but particularly on the patent revocation side.
Right.
I could almost guess the decision was going to be, in consideration of common general knowledge and the prior art, the patent's invalid. So you toss, and CGK just became the favorite thing, and then they added a bit of insufficiency for your pharmaceutical patents, but everything was being tossed out as invalid, which of course discourages litigation. But I think, I mentioned the IP courts in 2014. By 2012, 2013, that was changing, and there was a realization that IP cases in particular have to be decided fairly because you're creating an ecosystem. People have to see how people fare, and it doesn't matter. There's no black hats or white hats in IP, particularly in patents. You have a patent, it may be valid, it may be valid. It doesn't matter if you're a good guy or a bad guy. It shouldn't matter at all. It just really matters is, after considering the law, do we find this patent valid and infringed or not?
Right.
End of story.
Right.
And I think that realization has fed through, which is why we've now got, I don't think people complain particularly about any particular bias, except obviously in the SCP world with these anti-suit injunctions, but any particular bias in decision-making at any level. You'll still have some outlying decisions, but you get them everywhere in the world. So,
do they still have, we haven't talked about, I hear what you're saying. We talked about the revocation process, which is not in the courts. It's sort of, it's like an equivalent system to the American IPRs, I guess.
Yes.
And it used to be that there was serial filings, sometimes even with very similar, if not identical, firearms, and a lot of ex parte communication with judges, which is not illegal in China, but just rubs patent owners the wrong way, I guess, or Western patent owners. How has that developed, if at all, since the
Well, again, I mean, I think now it's CNIPA, still professional. You still have some of these issues. I mean, it's a much more informal system, like in Germany. Don't forget, in Germany, you have a lot of ex parte communication too. So it's not it's not just China.
Rubbed me the wrong way too. But even when it was in my favor, I said, "Are you sure you're allowed to do that?"
Yeah, I've always thought that in Germany it's even more than China. Like literally, can I have an extension of time? Sure. Like you're not going to ask the other side. Like it's like But actually, the invalidation, they're very professional now. You've got panels who've been deciding lots of complex cases. Serial filing still happens, but that's just a life, like what you expect if you're in these type of cases. Probably the most interesting thing that's happened, because one of the biggest problems, just like in Germany, was if you got parallel proceedings for validity and infringement, you don't get the squeeze argument on a patentee sometimes. And I actually had this case where literally, in the invalidation proceedings, the patentee said, that feature is irrelevant, so you can ignore it, to keep the patent valid, and then won by claiming that feature in the litigation. And the court just said, oh well, we just have to we just have to read the patent as it is. Very unfair. Apparently it can happen in Germany too.
Right.
But what the Supreme Court is doing now is they have actually heard a number of invalidation and infringement cases together on appeal. And I think they're trying to do that more and more, because that helps solve that problem of being able to sort of assert one thing in one firm and assert one thing in the other. They should have some better rules on it. But that was an old case where I lost a long time ago, and there's certainly some local issues going on there, no doubt about it.
So moving from sort of the practice of law to the practitioners of law in China and in Hong Kong, I know that there's a lot of issues that I've talked about with you over the years, but I guess the nature, at least it was last I looked into this old information. I'm curious how it works. There's like five foreign firms that had certain set of rights to work in China. But if you really wanted to do something in the courtroom or before a Chinese agency, you needed certain kind of Chinese firms, and it was a whole sort of weird sort of dance you had to play, especially between the foreign firms and the Chinese firms, and then compounded by the fact if it was a multinational litigation that involving common law countries, that at least many courts in the U.S. and I believe the UK don't find that Chinese lawyers who are acting as Chinese lawyers and are solely Chinese lawyers attach privilege to their communications to their clients and to and from their clients.
Yeah. Well, let's take the privilege issue first. That's still there. I think it's mainly the US. Hong Kong courts decided that they will attach privilege, just because we attach privilege to as much as we can. We've actually got some of the best rules on privilege, even compared to the UK, because the UK has carved down a lot, not as much as the US, at least for foreign lawyers. I think they take a more simple view in Hong Kong. Look, communication between lawyers, prima facie privilege. Let's not go into all this investigating everything in depth. But going back to so there's been a number of changes in the system as well. So, for example, Rouse has an associated firm that we litigate through in China and do a lot of local litigation.
Is it also called Rouse, or you have to have a different brand?
It's called Lusheng, Lusheng. It could be called Rouse, but it's been called Lusheng for years. It's associated. I mean, because of the regulations and structures, it's not directly owned by Rouse, but it's been people there for a long time. And so Rouse has been doing that, and so we litigate. My team litigates in the Chinese courts, but also even for foreign firms, they changed the rules actually about 8 years ago now. So that foreign firms can set up local law firms in the Shanghai Free Trade Zone, which is the whole of Pudong. And so quite a few foreign firms have their what we call FTZ firms, and they're allowed to litigate any court in China. So a lot of the big firms all have, and my old firm, Lovells, Baker McKenzie, Allen Overy, they all have these firms, and they are joint ventures. They are technically a separate legal entity, but they can share profits and all those other things. So it's effectively that they've got their own firms there. So
I imagine there's a lot of challenges within the firm handling the various demands of different countries with respect to information and regulations that make it a lot of dancing along the lines to make everyone happy.
Yeah, well, I think it's strange. I think the FTZ firms probably do better. It's like cryptocurrency. Let's give you another. It's like cryptocurrency. A lot of cryptocurrency firms have moved to the Bahamas. Why? Because they've got regulations, and it's much better to be in a regulated environment than in a. They were in Hong Kong where it's unregulated, but you never know what's going to happen. The FTZ firms have regulations, have rules saying what you can and can't do. So it's much better to have some bright lines than just sort of try and figure out where we're going. So you're talking. I think you're raising the issue. Yeah, you're talking about dancing and stuff. Yes, yeah. Because foreign firms before that had to have all sorts of working with local firms and not being associated, and where was the line, what could you do, what couldn't you do. It was all a little bit complex, whereas now it's pretty clear.
Right. And so a hypothetical client would looking for a to prepare themselves for a big Chinese litigation with something before CIPO and in the courts. Would you recommend that they just get one? I mean, obviously, Rouse could do it all, or is that something that different firms handle traditionally, or?
Most firms do it all, but if you obviously if you're looking at patents, I mean, depending on the area of technology, like you would even in the US, you might look for a patent agent for that area of technology working with another firm. It just really depends on the case. I mean, and of course, team sizes. I mean, even now compared to say the US, none of the firms have the massive team sizes you see in some other jurisdictions. Like even the UK and US. So yeah, I mean, we handle some of them, we handle it all. Other cases, we work with other people. Particularly when you get into arbitration, you're often co-counseling because it's
I understand.
So big, and you've got
one of the things on that particular point in the U.S. and I believe in the U.K. Well, in the U.S., one of the reasons why it's such big teams is you have document and deposition discovery, which just metastasizes the amount of things that people have to be aware of and dealing with. And then in the UK, you get a lot of complicated motions and expert reports and things like that. Is that, my recollection was that China was much more limited than that, was more sort of German in style, but is that true?
No, that remains the case. It's much more German in style. It's still limited. So you don't need the huge teams to do the discovery side, particularly the US style discovery. But you do need huge teams to try and get evidence in other ways because you still need evidence. Actually,
are there still a lot of restrictions about doing that? Like, I remember some people that would tell me offer ways to get evidence that were sort of quasi-legal, but maybe legal after it was gotten.
Yeah, it's actually getting tougher. So, you have to collect evidence that's notarized and legalized, or somehow you can prove a chain, like you have to do in a criminal court in most countries of the world. You have to prove a chain of title originality, which most civil courts have abandoned. Basically everything's admissible. Doesn't matter where it came from. You can say it was pushed under the door at night, but here it is. Can't do that in China. You've got to have, where did it come from? What is it? Unless the other side admits the document, of course. So before, yes, you could often rely on maybe semi-legal ways of getting evidence, but we're there. Investigators going in and filming stuff, for example. But there have been a number of cases where both the law firms and the companies have been sued for breach of privacy or breach of trade secrets from investigating, sort of countersuit when someone gets angry. So, and they can cause you a lot of stress, even if you
is it legal to do reverse engineering though?
That's fine.
Okay.
Problem is, then you proving reverse engineering is hard anywhere. I mean, if you're doing real reverse engineering, it's hard anywhere. You're stripping a chip. I mean, even in the US, that's still a difficult one to bring before the court.
That's hard, and then you have to prove that this is the chip that's being sold. And sometimes, especially if it's not a commodity product, you have to. How are you going to prove that you got the product?
Yes.
No, I understand. So, another thing that I understand has changed was, and I'm sure Rouse's pricing and efficiency levels are perfect, but the Chinese firms, as I recall, the prices have been going up and are starting to match U.S. levels of inflation. Is that correct, or is it sort of?
It's an interesting market. It's actually, at the top level, the patent sort of litigation stuff, absolutely. You're looking at some very high prices for, basically higher hourly rates that have gone up. And once you have higher hourly rates for a big team, you end up with some big bills. Probably still not quite as expensive as the US because the teams aren't quite so big.
Right.
But at the other end, if you're just looking at your sort of brand protection things, there's a lot more firms to do it. So competition has started to cut into there. But when you're dealing with the really big stuff where there's limited competition, you are looking at some of the big local firms charging even more than foreign firms.
Wow. Well, one of the reasons why it might be cheaper, and I'm curious if this is the case, is that in Germany, while maybe not best practice as an attorney or best practice to allow as an in-house attorney to allow your clients to do this, the nature of litigation is sort of almost like prosecution. You have some things you got to do. You file the response, you file it in, and then you sort of wait till the next due date, and you sort of deal with it then, as opposed to both, I guess, most common law countries where there's sort of a steady burn. In the U.S., the burn is pretty high. In the U.K., it's a little lower, but there's a steady burn of stuff that's going on. Is that so? What's the nature, the rhythm of the case in China?
It's probably a little bit. I mean, the basic principles are a lot more like Germany, but they can get going pretty fast. So particularly as a plaintiff, you've got to front load a lot because you've got to get everything together. You've got to have all your evidence together because the court can, it may not, but it can often give you a hearing date within 6 months. And so that means you've got to get everything ready to go.
Right.
It may slow down, and it may stop for a while, a little bit like Germany. You don't get the sort of motion practice other than jurisdiction challenges we did a couple of, if you remember. But
I remember.
You don't get the motion practice like you have in the US or the UK, because it's pretty much plaintiff come to court, prove your case. It's like almost being a prosecutor, like you said. Prove your case. Defendant, you can do what you want. I mean, now more defendants do engage, but still defendants can often just say, well, you can't prove that, you can't prove this. So the cases can move pretty fast. But, you do have work in the background. Don't forget, any patent case, you'll have the invalidations running off to the side. And so your team will still be pretty busy. But, nothing like a common law big suit where you've just got documents.
On appeal, remind me, is it like Germany where the factually Denovo, or is it more like the UK? Or
the facts can be Denovo, but the appellate courts have been tightening up. It used to be pure Denovo. It was actually pretty scary because your trial was pretty much pointless, and you go up on a Denovo
trial run, literally.
Yeah, literally a trial run. On appeal now, I think particularly the Supreme Court is like, okay, trying to limit the admission of new evidence, but it's not to the point of, say, UK or I assume the US, you can't. Effectively, getting new evidence in on appeal is almost impossible if you've had a jury trial in particular.
Right.
But even the UK and Hong Kong, very strict rules on new evidence. You can't, it's new, or you couldn't have got it, or whatever. And even then, they may not have missed it because then it still has to be highly probative and probably going to change the decision. Otherwise. So China's not to that standard, but they certainly have issued rules tightening the admission of new evidence on appeal, and I'm sure in some cases implementing. I haven't actually had to deal with that issue specifically. I mean, yes, it's getting to the point you want to make sure you have all your ducks in a row. I was going to say ducks and drakes, but I think ducks in a row before you go into court.
Yeah, well, as long as they're not squashed like a Peking duck. So, the great Professor Mark Cohen has no relation with has been tremendous work on the statistics coming out of China. I know the Chinese are doing their own statistics, but he's been translating it to the Western audience. So, if I got this wrong, it's my fault, not his. But my understanding is that the volume of patent litigation in China sort of dwarfs the U.S. by like a factor of 2. Or something remarkable like that. Is it really? Are those mostly smaller cases or bigger cases, or it's hard to?
Yeah, you got a real problem with the Chinese statistics for 3 reasons, actually 4. First, you got design patents, which are counted as patents, and so a lot of people talk about doing a patent. Well, it's a design patent case, and for example, we've got one case for a client where we filed 25 different cases because this is the second point. Most courts require you to file 1 case per patent.
I see, like Germany.
Unlike the US or common law, where you put 25 into 1 case, so therefore it's pretty easy to, and that's where your statistics don't necessarily capture. Someone will have to go down and say, how many patents were in suit in the US, because most US patent cases have 2 or 3 patents, not necessarily, but often they do.
Yeah, it's not more.
Most do. Yeah, because you don't want to just put all your eggs in one basket. getting into another analogy, but
Right.
whereas
Well, the eggs came from the ducks in a row.
the ducks that got crushed or didn't. And so you got the problem of it's one case per case. So pure case numbers, high. And then you get the other problem, which I think is even hard to capture, is a lot of them are utility models, which are just rubbish cases, most of them. Not all of them. Some of them are serious, but utility models, as you know, unexamined, and you get a lot of people running around suing on those things. Most get invalidated. So I haven't looked at Mark's most recent statistics, but you have to adjust for all those.
Right. But it's still tremendous. I mean, compared to say, this is sort of was a lead up to my next question, which is compared to say, I mean, Japan, Korea, Taiwan, Indonesia, Malaysia, and I don't know about India so much, but the other East Asian and South Asian countries where you might choose to litigate patents, it dwarfs them all by some significant number.
It does, and there's some other factors for that. First is partly the utility models, because you get it granted. Secondly, you can run a simple case pretty cheaply. As a foreigner, you may not want to. You want to go to a big firm and do everything properly. But all these Chinese guys, particularly the let's call them non-practicing entities. Is
that a thing now in China?
Oh, big thing. There's a lot of guys who have these patents, particularly utility models, run around, and they're effectively trolling. I mean, seriously, you got something. I had one client get someone had a twist top bottle for a beer, and they were importing beer from Australia with twist top bottles. Got sued on a utility model, and these twist top bottles have been out in Australia for 15, 20 years, and the guy's got this patent. You say, well, prior art defense, but they don't care, because pay me 10,000 RMB and I go away. And just the cost of a real troller. So just the cost of even trying to invalidate it is just not worth it. So you say, okay, fine, I'll just pay you.
Right.
And so,
but do these other countries, other jurisdictions, I should say, play a role? I guess if you were to advise someone sort of a general IP strategy for monetization and whatnot, how important do these other jurisdictions play in your strategy, or is your suggestion mostly China or Penn?
I always look for at least another pressure point somewhere. Take like anywhere. This is not China. This is just general litigation. Take someone out of their comfort zone. So an American company, you're going to sue them somewhere else just because China, Japan, somewhere else where they have to go into another place in another language, another system they don't understand. So of course you look for that pressure point. For us at the moment, for me personally, Indonesia is probably the most interesting place because the courts there are required to finish a case within 6 months. So you've got speed. You've got speed. They're very fussy about formalities, partly for that reason, because they can kick a case on a formality, then they will, rather than have to deal with the substantive issue. But it's a big country. You're looking at it's
heavily population too.
300 million people with a growing economy for a long time. So Indonesia is the next big IP highlight in Asia for every country, every company, pharma in particular, but also now mobile handset makers, because they're all it's 300 million people. That's a big market.
No, of course, and the sort of my next sort of line of questions, the whole confluence of stuff that's happened over the past few years, COVID, war, disengagement, or whatever you want to call it, the trade war, all this other stuff has sort of been impacting everything. And I guess the first question, which might be easier than the second, or easier to answer, has sort of the disengagement impacted, or has competition or the competitive effect or something about China sort of triggered these other countries in East Asia to up their game as far as IP ecosystem?
I think certainly India. And you've seen that, they suddenly got these commissioners hearing at least the injunction part of cases and doing things really quickly. There's no doubt that the sort of Chinese effect there on the India, because they're a bigger market and they don't want to be left behind, although they have a lot to do to fix the Indian legal system. I think other countries less so. because there's still big separation. It's still China and other places. Probably what we're seeing more, though, most interestingly, is Chinese companies are starting to export into Asia a lot more, and then they have to deal with these other legal systems. They turn up in Vietnam, they turn up in Indonesia, they turn up in Malaysia, they've turned up in Hong Kong for a long time. One of my favorite things has always been suing mainland Chinese companies in Hong Kong, because they come out, first foothold they put is in Hong Kong. They think they've got a legal system that, like China. And, I remember doing one case not so long ago for some servers, and they copied some software. In China, that was a nightmare case to pull the software off the server, prove that used it. I think they had a shock to their system to realize all we had to do was put an affidavit in from our client's own employee. Yeah, I downloaded the software. Here's a comparison. It infringes. And their lawyers would have told them, yeah, unless you've got another story to tell.
That's the problem. Yeah. Well, I mean, it's interesting because I know you've written a book or two or three on this, but so the various concessions back 150 years ago that the Western powers had in China, where they sort of applied their own laws. And I'm curious, given what you just said, do you think a sort of a more 21st century version of that might emerge, where sort of Chinese entities are dealt with under certain principles that don't necessarily apply to the rest of the people under that jurisdiction?
No, don't think so. No, I mean, not in general. I mean, obviously, if you have a big influence in some of these countries, which some of these investors do, that's the same thing. Americans have companies that often had.
Yeah, I know. I was gonna specifically blame American companies too, that they come to these countries and they say, you got to do, here's our way of doing things. This is the way we're going to do stuff.
Yeah, and if you don't, we're going to pull our investments. So you better, I mean, you'll get that in some areas, but not generally, not in IP, not generally in IP. But it's going to be interesting. Vietnam's the other big country, but their legal system's back where China was in the early 2000s, very slow, a bit ponderous, except for one thing, except on the anti-counterfeiting side, which is not really what we do, where they've had so if you go to Vietnam, you see almost no counterfeits because they've had the police enforcing anti-counterfeiting law for years. So it's actually, they've been stricter. But the civil litigation.
It shows a certain level of sophistication on the powers that be, because they know what side their bread is buttered. Like if they have.
I think it's also. I think it's actually just more generally that Vietnam never went through the Cultural Revolution or huge ructions. Okay, they had the war, but it's a very organized country. So coming from China, which is now getting more organized, which was not that organized compared to Vietnam. Very organized, very structured. So very interesting country to be. So we're looking at all this Vietnam, particularly because decoupling. We talk about decoupling now, which companies, not so much decoupling, but also now, if people don't see China as a country risk with all these lockdowns, everyone used to talk about, okay, we need to spread our risk, but never did it. If they don't now see with lockdowns and plants closures and border closures that there is a serious country risk, I'd be surprised. I think people are now seriously, okay, we've got to spread our risk and put plants in other places or bring them home. I mean, this is the biggest change. This is the next big step in IP, is manufacturing costs worldwide are equaling out, because even in China, cheap labor is not what does it anymore. It's the robots, it's the equipment.
Yeah.
And so
it'll be interesting to see how the Chinese try to export their IP from as licensors. Sort of like what somewhat cynically what I believe somewhat cynically what Huawei did in Texas, which was they were kicked out of the country in the U.S. that is, but they had a pretty robust portfolio, and they started suing the carriers in East Texas, which is funny. But I imagine we might see more of that in the future.
Yeah, there'll be far more of that. I say Huawei is exceptional, but there are other companies. They're building decent portfolios. I think the statistics are starting to show. There used to be a time when we talked about Chinese patents, huge numbers of domestic filings, very few going to grant outside China, but that's changing. I think still statistically lower than other countries, like in a number of, say, Japanese or American patents that go to grant in other jurisdictions is still statistically higher, but it's certainly changing. The quality, and the Chinese government's now shifted very clearly from quantity to quality. Last year, they actually announced it. Said, look, we're not going to give all these subsidies for you to file rubbish patents. They actually have that's the term in Chinese. They actually have, let's call them junk patents. We're not going to do that anymore. We're now moving on to quality because, these things just stuff up the system and you get litigation around bad stuff. So, but
good for them.
Well, I'd say the quantity thing worked though. I mean, it was pure industrial policy, but by subsidizing filings, they got companies to have some portfolios that they could then realize, going right back the full circle, they could monetize,
right?
Or it helped them to keep competitors out. So the government did build knowledge of the value of IP by helping people get IP. And I think now more people have built into it that we need to budget for this, because otherwise we will not succeed in our industry without some IP.
That's fascinating. It's fascinating. I'm sure books, I think you've written a book could be written about this.
I haven't done it on that actual point because it would take some economic statistics, which I'm not particularly too keen to get into.
Well, maybe you and Mark could put something together. But just, I guess, to close it out, how has COVID impacted in the day-to-day practice of what you do? And do you think anything good from it will stay? I mean, hopefully the bad stuff will go, but anything. So, like, I speak to a lot of lawyers, and what I mean by that is I speak to a lot of lawyers in the States who say, there's no reason why I have to fly halfway to the country, around the country, for a scheduling conference, or we should be able to do that by video. Just sort of.
That's the same in China. That's the number one biggest change. Because Chinese courts actually shifted very quickly online, anything scheduling, interlocutory, minor applications, all just going to be done online, even if you're in the same city. Apparently, now in Australia, one of my friends practices there, says the simple applications, you're literally just sitting at your desk. The court clerk sends you a message 5 minutes before, you're going to be on in about 5 minutes, turn on your camera, and then they call your case, you're sitting there, you make your application, the other side's heard, judge makes a decision. No one turns up in court anymore. Yeah, so what was a good morning out, cup of coffee with your mates, a nice big fee, all gone now. Now you're just charging for well, you still charge a bit, but you're basically charging, it's going to catch up with you.
No, of course. And I'm sure you've had or you've heard about enough versions of the I Am Not a Cat episode.
Yes. So in fact, this online court has been great, because even when Shanghai was locked down, a lot of my team in Shanghai could still do their court hearings. Not in Shanghai. The Shanghai courts closed because no one was around to set up. Although in the UK, they managed to do it even during lockdown. That was very impressive.
I remember, yeah.
But that's UK is impressive on that side. People were still locked down in their homes, but they could do online hearings around the country, full trial hearings. Not to forget that a Chinese trial, and this is probably a good way to get close to an ending, is a totally different experience to a common law trial. It's literally it's like a paper hearing, because and it's very, very formulaic. You go through a number of different stages. So it is very suited to online, because it's not really based around fantastic advocacy or making points. It's literally, you're just grinding through the papers. Here's the evidence. The judge is asking a lot of questions. I mean, you've seen German hearings, very much more similar. It's that type of hearing is very suited to a online presentation.
Right. I used to joke in Germany that you're winning when your lawyer looks bored.
Because they're asking questions to the other side. Yeah, right.
Yeah, exactly. And the hard questions, your lawyer just, is this the evidence? Yeah. Anyway, listen, Doug, this has been great. I really appreciate all this time that you've spent. That you clearly have a lot more information, and we haven't even talked about your movie career and your fun books.
Let's talk about them quickly. Movie career. That's simply. If you don't invest in art house movies, is all I'll say. Like you get to be an associate producer, but you pay a lot of money for that title, and you don't see the return. And the movie actually made money, but it's just like you learn the cascading of who gets the money doesn't get down to you. Lesson learned. And the books are wonderful. Yeah, Gunboat Justice, for those watching, look it up. It's a
great read. It's a great read for legal history. It's a great read.
Yeah. So as a practicing lawyer, I was able to read the transcripts and understand what was going on, or think I understand what was going on. So
and you paint a great picture too. So definitely. Well, Well, thank you, Doug. And stick around a bit after we close out here.
Okay, no problem.